In spite of the above criticisms and shortcomings, the directive principles are an unnecessary appendage to the Constitution. The Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhvi, an eminent jurist and diplomat, the directives are the life-giving provisions of the Constitution. They constitute the stuff of the Constitution and its philosophy of social justice. 16. M.C. Chagla, former Chief Justice of India, is of the opinion that, if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense but also a welfare state looking after the welfare of its citizens. 17. Dr. B.R. Ambedkar had pointed out that the directives have great value because they lay down that the goal of Indian polity is economic democracy, as distinguished from a political democracy. Granville Austin opined that the directive principles are aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. 18. Sir Ben Rao, the constitutional advisor to the Constituent Assembly, stated that directive principles are intended as moral precepts for the authorities of the state. They have at least an educative value. According to M.C. Setalvad, the former Attorney General of India, the directive principles, although confer no legal rights and create no legal remedies, are significant and useful in the following ways. 1. They are like an instrument of instructions or general recommendations addressed to all authorities in the Indian Union. They remind them of the basic principles of the new social and economic order, which the Constitution aims at building. 2. They have served as useful beacon lights to the courts. They have helped the courts in exercising their power of judicial review, that is, the power to determine the constitutional validity of a law. 3. They form the dominating background to all state action, legislative or executive, and also a guide to the courts in some respects. 4. They amplify the preamble, which solemnly resolves to secure to all citizens of India justice, liberty, equality and fraternity. The directives also play the following roles. 1. They facilitate stability and continuity in domestic and foreign policies in political, economic and social spheres in spite of the changes of the party in power. 2. They are supplementary to the fundamental rights of the citizens. They are intended to fill in the vacuum in Part 3 by providing for social and economic rights. 3. Their implementation creates a favorable atmosphere for the full and proper enjoyment of the fundamental rights by the citizens. Political democracy, without economic democracy, has no meaning. 4. They enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directives. 5. They serve as a crucial test for the performance of the government. The people can examine the policies and programs of the government in the light of these constitutional declarations. 6. They serve as common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher and friend in its legislative and executive acts. 19. Conflict between fundamental rights and directviveprinciples. The justiciability of fundamental rights and non-justiciability of directive principles on the one hand and the moral obligation of state to implement directive principles, Article 37, on the other hand have led to a conflict between the two since the commencement of the Constitution. In Thechampakam Dorayarajan Case 20, 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and the directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights. But, it also held that the fundamental rights could be amended by the Parliament by enacting constitutional amendment acts. As a result, the Parliament made the First Amendment Act 1951, the Fourth Amendment Act 1955, and the 17th Amendment Act 1964 to implement some of the directives. The above situation underwent a major change in 1967 following the Supreme Court's judgment in the Golanath Case 21, 1967. In that case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights, which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of the directive principles. The Parliament reacted to the Supreme Court's judgment in the Golanath Case, 1967, by enacting the 24th Amendment Act, 1971, and the 25th Amendment Act, 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away any of the fundamental rights by enacting constitutional amendment acts. The 25th Amendment Act inserted a new Article 31C which contained the following two provisions. 1. No law which seeks to implement the socialistic directive principle specified in Article 39, B22 and C23 shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, Article 19, protection of 6 rights in respect of speech, assembly, movement, etc., or Article 31, right to property. Point 2. No law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Table 8.1 Distinction between fundamental rights and directive principles. Fundamental rights directive principles. 1. These are negative as they prohibit the state. 1. These are positive as they require the state to from doing certain things. Do certain things. 2. These are justiciable, that is, they are legally enforceable by the courts in case of their violation. 2. These are non-justiciable, that is, they are not legally enforceable by the courts for their violation. 3. They aim at establishing political democracy in the country. 3. They aim at establishing social and economic democracy in the country. 4. These have legal sanctions. 4. These have moral and political sanctions. 5. They promote the welfare of the individual, hence, they are personal and individualistic. 5. They promote the welfare of the community, hence, they are societarian and socialistic. 6. They do not require any legislation for their implementation. They are automatically enforced. 6. They require legislation for their implementation. They are not automatically enforced. 7. The courts are bound to declare a law violative of any of the fundamental rights as unconstitutional and invalid. 7. The courts cannot declare a law violative of any of the directive principles as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. In the Kesavananda Bharati Case 24, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. Later, the 42nd Amendment Act, 1976, extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39B and C. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principles over the fundamental rights conferred by Articles 14, 19 and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills Case 25, 1980. It means that the directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred by Article 14 and Article 19 were accepted as subordinate to the directive principles specified in Article 39B and C. Further, Article 31, right to property, was abolished by the 44th Amendment Act, 1978. In the Minerva Mills case, 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between the two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Therefore, the present position is that the fundamental rights enjoy supremacy over the directive principles. Yet this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles, so long as the amendment does not damage or destroy the basic structure of the Constitution. Implementation of directive principles. Since 1950, the successive governments at the center and in the states have made several laws and formulated various programs for implementing the directive principles. These are mentioned below. 1. The Planning Commission was established in 1950 to take up the Development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status and opportunities. In 2015, the Planning Commission was replaced by a new body called NITI AAYOG, National Institution for Transforming India. Point 2. Almost all the states have passed land reform laws to bring changes in the agrarian society and to improve the conditions of the rural masses. These measures include a. Abolition of intermediaries like zamindars, jagirdars, inamdars, etc. b. Tenancy reforms like security of tenure, fair rents, etc. c. Imposition of ceilings on landholdings. d. Distribution of surplus land among the landless laborers, and e. Cooperative farming. Point 3. The Minimum Wages Act 1948, the Payment of Wages Act 1936, the Payment of Bonus Act 1965, the Contract Labor Regulation and Abolition Act 1970, the Child Labor Prohibition and Regulation Act 1986, the Bonded Labor System Abolition Act 1976, the Trade Unions Act 1926, the Factories Act 1948, the Mines Act 1952, the Industrial Disputes Act 1947, the Workmen's Compensation Act 1923, and so on have been enacted to protect the interests of the labor sections. In 2006, the government banned the child labor. In 2016, the Child Labor Prohibition and Regulation Act 1986 was renamed as the Child and Adolescent Labor Prohibition and Regulation Act 1986.4. The Maternity Benefit Act 1961 and the Equal Remuneration Act 1976 have been made to protect the interests of women workers. Point 5. Various measures have been taken to utilize the financial resources for promoting the common good. These include nationalization of life insurance, 1956, the nationalization of 14 leading commercial banks, 1969, nationalization of general insurance, 1971, abolition of privy purses, 1971, and so on. Point 6. The Legal Services Authorities Act 1987 has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalats for promoting equal justice. Lok Adalat is a statutory forum for conciliatory settlement of legal disputes. It has been given the status of a civil court. Its awards are enforceable, binding on the parties, and final as no appeal lies before any court against them. Point 7. Khadi and Village Industries Board, Khadi and Village Industries Commission, Small Scale Industries Board, National Small Industries Corporation, Handloom Board, Handicrafts Board, Quar Board, Silk Board and so on have been set up for the development of cottage industries in rural areas. Point 8. The Community Development Program, 1952, Hill Redevelopment Program, 1960, Drought-Prone Area Program, 1973, Minimum Needs Program, 1974, Integrated Rural Development Program, 1978, Jawahar Rozgar Yojana, 1989, Swarna Jayanti Gram Swarazgar Yojana, 1999, Sampoorna Gramina Rozgar Yojana, 2001, National Rural Employment Guarantee Program, 2006, and so on have been launched for raising the standard of living of people. Point 9. The Wildlife Protection Act 1972 and the Forest Conservation Act 1980 have been enacted to safeguard the wildlife and the forests respectively. Further, the Water and Air Acts have provided for the establishment of the central and state pollution control boards, which are engaged in the protection and improvement of environment. The National Forest Policy, 1988, aims at the protection, conservation and development of forests. Point 10. Agriculture has been modernized by providing improved agricultural inputs, seeds, fertilizers and irrigation facilities. Various steps have also been taken to organize animal husbandry on modern and scientific lines. Point 11. Three-tier Panchayati Raj system, at village, taluka and zilla levels, has been introduced to translate into reality Gandhiji's dream of every village being a republic. The 73rd Amendment Act 1992 has been enacted to provide constitutional status and protection to these Panchayati Raj institutions. Point 12. Seats are reserved for SCs, STs and other weaker sections in educational institutions, government services and representative bodies. The Untouchability Offences Act 1955, which was renamed as the Protection of Civil Rights Act in 1976, and the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, have been enacted to protect the SCs and STs from social injustice and exploitation. The 65th Constitutional Amendment Act of 1990 established the National Commission for Scheduled Castes and Scheduled Tribes to protect the interests of SCs and STs. The 89th Constitutional Amendment Act of 2003 bifurcated this combined commission into two separate bodies, namely, National Commission for Scheduled Castes and National Commission for Scheduled Tribes, 12A. Various national-level commissions have been established to promote and protect the social, educational and economic interests of the weaker sections of the society. These include the National Commission for Backward Classes, 1993, the National Commission for Minorities, 1993, the National Commission for Women, 1992, and the National Commission for Protection of Child Rights, 2007.13. The Criminal Procedure Code, 1973, separated the judiciary from the executive in the public services of the state. Prior to this separation, the district authorities like the collector, the subdivisional officer, the tehsildar and so on used to exercise judicial powers along with the traditional executive powers. After the separation, the judicial powers were taken away from these executive authorities and vested in the hands of district judicial magistrates who work under the direct control of the state high court. 14. The Ancient and Historical Monument and Archaeological Sites and Remains Act 1951 has been enacted to protect the monuments, places and objects of national importance. 15. Primary health centers and hospitals have been established throughout the country to improve the public health. Also, special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, kala-azar, guineaworm, yaws, Japanese encephalitis and so on. 16. Laws to prohibit the slaughter of cows, calves, and bullocks have been enacted in some states. 17. Some states have initiated the old age pension schemes for people above 65 years. 18. India has been following the policy of non-alignment and Panchsheel to promote international peace and security. In spite of the above steps by the central and state governments, the directive principles have not been implemented fully and effectively due to several reasons like inadequate financial resources, unfavorable socio-economic conditions, population explosion, strained center-state relations and so on. Join Facebook group, study materials for WBCSIAS and other government jobs. Directives outside Part 4. Apart from the directives included in Part 4, there are some other directives contained in other parts of the Constitution. They are, 1. Claims of SCs and STs to services. The claims of the members of the scheduled castes and the scheduled tribes shall be taken into consideration, consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts in connection with the affairs of the Union or a state. Article 335 in Parts v.2. Instruction in mother tongue. It shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350A in Parts v.3. Development of the Hindi language. It shall be the duty of the Union to promote the spread of the Hindi language and to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India. Article 351 in Part 17. The above directives are also non-justiciable in nature. However, they are also given equal importance and attention by the judiciary on the ground that all parts of the Constitution must be read together. Table 8.2 Articles related to directive principles of state policy at a glance. Article No. Subject matter. 36. Definition of state. 37. Application of the principles contained in this part. 38. State to secure a social order for the promotion of welfare of the people. 39. Certain principles of policy to be followed by the state. 39A. Equal justice and free legal aid. 40. Organization of village panchayats. 41. Right to work, to education and to public assistance in certain cases. 42. Provision for just and humane conditions of work and maternity relief. 43. Living wage, etc., for workers. 43A. Participation of workers in management of industries. 43B. Promotion of cooperative societies. 44. Uniform civil code for the citizens. 45. Provision for early childhood care and education to children below the age of 6 years. 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. 48. Organization of agriculture and animal husbandry. 48a. Protection and improvement of environment and safeguarding of forests and wildlife. 49. Protection of monuments and places and objects of national importance. 50. Separation of judiciary from executive. 51. Promotion of international peace and security. Notes and references. 1. Actually, directive principles are mentioned in Articles 38 to 51. Article 36 deals with the definition of state, while Article 37 deals with the nature and significance of directive principles. 2. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966 p. 75.3. A police state is mainly concerned with the maintenance of law and order and defense of the country against external aggression. Such a restrictive concept of state is based on the 19th century theory of individualism or laissez-faire. 4. This second provision was added by the 44th Constitutional Amendment Act of 1978.5. The last point, F, was modified by the 42nd Constitutional Amendment Act of 1976.6. This direct 2. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966 p. 75.3. A police state is mainly concerned with the maintenance of law and order and defense of the country against external aggression. Such a restrictive concept of state is based on the 19th century theory of individualism or laissez-faire. 4. This second provision was added by the 44th Constitutional Amendment Act of 1978.5. The last point, F, was modified by the 42nd Constitutional Amendment Act of 1976.6. This directive was added by the 42nd Constitutional Amendment Act of 1976.7. Living wage is different from minimum wage, which includes the bare needs of life like food, shelter, and clothing. In addition to these bare needs, a living wage includes education, health, insurance, etc. A fair wage is a mean between living wage and minimum wage. 8. This directive was added by the 42nd Constitutional Amendment Act of 1976.8a. This directive was added by the 97th Constitutional Amendment Act of 2011.9. This directive was changed by the 86th Constitutional Amendment Act of 2002. Originally, it made a provision for free and compulsory education for all children until they complete the age of 14 years. 10. This directive was added by the 42nd Constitutional Amendment Act of 1976.11. Constituent Assembly Debates, Volume 7, p. 476.12. M.